it turns out the founders were much more Republican or Democratic than it's often thought. They're far less libertarian. And by that, I mean that they established government by the people, and that the natural rights understanding that I try to outline, and it's not my understanding of this, I'm trying to explain this is the founders' understanding, would mean there are very few things government can't do, but most things when it comes to church and state, the founders' position was you turn it over to local democratic majorities.
Hi, for this episode of Scholar Talks, the guiding question is, how did the American founders understand religious liberty? And our guest today is Vincent Phillip Muñoz, who is a professor of political science and a professor of law at the University of Notre Dame. He is the founding director of the Notre Dame Center for Citizenship and Constitutional Government. And Dr. Muñoz writes and teaches about constitutional law, American politics, and political philosophy, with a focus on religious liberty and the American founding, which is the subject of several of his books. He's the author and editor of several books, including the newly published Religious Liberty and the American Founding, Natural Rights, and the Original Meanings of the First Amendment Religion Clauses. I am Tony Williams, Senior Fellow at the Bill of Rights Institute, and I'm pleased to bring you another episode of Scholar Talks in our series Topics in Government and Civics. Philip, I want to thank you very much for joining us.
It's a pleasure to be with you.
Yeah, I really love your new book. It's very judiciously argued. I think it's very well balanced, well argued, very, very, very interesting, tapping into religious liberty and the founders, but then also modern Supreme Court cases. Really, really fabulous book. And I love the way you're very fair-minded about the evidence, right? You don't cherry pick this founder or that founder, but you really try to go to a deeper understanding of religious liberty in the American founding. So well done.
Well, thank you. I mean, that means quite a lot to me coming from you. And yeah, the book is, it just tries to present the historical record, the historical evidence. I'm not trying to argue for a specific point of view. I have my views, but it just tries to be a piece of honest scholarship.
Right. Well, let's dive in. Speaking of scholarship, for this first question, in the founding, you really dug a lot around in the state constitution, state declarations of rights, and the entire ratification debate. And so what were the two main common founding understandings of religious liberty that you found?
Yeah, good. Okay, well, so the founders agreed on matters of principle, and they all agreed, and you can see this in the leading documents of the time, especially in the state constitutions and the state declarations of rights. We just say one word about that. Starting in 1776, even prior to the Declaration of Independence, the states preparing for independence started drafting constitutions. And when they drafted constitutions, many of the states added a Declaration of Rights. Now, these are a little bit different than our Federal Bill of Rights. They're more like the preamble to the Constitution, or even like the Declaration of Independence. These are statements of political principles. These are the principles that inform the state constitutions that they were attached to. And so in these declarations of rights, we can find the founders' principles, and they all say the same thing about religious liberty, which is religious liberty is a natural and unalienable natural right. Now, what that means, I mean, I have to read the whole book to figure out what that means. But in essence, there are certain authorities or powers we don't give to government. We don't give the government the power to tell us how we ought to pray, or punish us for praying in a certain way, or punish us for not praying at all. There's a certain domain of our natural liberty, especially the way we worship, that we don't give authority to government. So government can do all sorts of things. It can help regulate property, set up laws pertaining to morality, but it can't tell us how to worship, or punish us for worship, or punishing us for not worshiping. Can't license ministers. So this is the natural right, the inalienable natural right, the core of the founders' understanding, and they all agreed to that. There's a certain domain. When we talk about limited government, this is one of the limits. Government can't punish you for how you pray or for not praying. That was their agreement. Now, the founders did disagree on how far government could go in terms of using religion to facilitate other valid civic aims. Could government have religious tests for political office? For example, the state of Massachusetts, you had to be a Protestant to be a senator, a state senator, or the governor. No, those tests were defended by saying, look, we want our office holders, especially our high office holders, to be virtuous. And how do we measure if someone is virtuous or not? Well, we have age requirements, we have residency requirements. An age requirement helps ensure that the person is of sufficient knowledge and experience. A residency requirement helps ensure that they're devoted to the state, that they have a stake in the community. And the argument was, well, a religion requirement, that they be Protestant, is a way we measure that they're virtuous. Some founders thought, okay, well, you can use religion to foster these otherwise valid civic aims, and a religious test for office would be an example of that. But other founders said, no, religion can't even be used as a means. So we should have basically a principle of non-discrimination, or government shouldn't pay attention to the religious affiliation of citizens. And that's a live dispute, and it manifests itself in all sorts of ways. Can government fund religion or not? And so where the founders agreed about the core natural right of religious liberty, they disagreed when it came to implementing that right in specific contextual cases.
Right, great. And there were also, if I recall, some areas of disagreement among the founders exactly on their understanding of religious liberty. Thomas Jefferson, Isaac Backus, and some others.
Yeah, and they reached the same conclusion about the core right, but in different ways. Jefferson followed John Locke, and really we say he's part of the secular Enlightenment. James Madison, his arguments were, he had some of the same arguments as Locke and Jefferson, but he also had a natural theology. Madison actually starts from man's duties to worship. The rights, Madison says we have rights among men because we have duties to God. I actually think this was commonly understood among the founders, that rights were not opposed to duties. In fact, political rights were meant so we could fulfill our duties. And then you had other founders very influential at the time, and I use Isaac Backus, who's probably the most influential Baptist preacher in the Northeast. Not the only one for certain, but a very influential gentleman. And their defense of the natural right to religious liberty was really biblically based. And so you have these arguments from scripture, you have these arguments from natural theology, and you have these arguments from secular philosophy, but they all reach the same place in terms of our natural rights understanding. The disagreements were really more on the level of policy. This is an old understanding of natural law thinkers or natural right thinkers. The further you get from the core understanding, the more you're likely to have disagreement. Those lower level disagreements shouldn't be interpreted to mean that there wasn't really a high level of agreement, at least on the matter of principle.
Right. Okay. And so what were your findings regarding your originalist understanding of the religion clauses of the First Amendment? And for our audience, we're specifically talking about the free exercise clause and the establishment clause. So how can that originalist understanding help us make sense of these, very contested religious clauses? Yeah,
very good. So, historians might look at the founders just because we want to understand what the founders thought. We can learn from history. Judges and legal scholars tend to look at the founders for purposes of constitutional interpretation. There's a type of a methodology called originalism. I'm sure most of your listeners are familiar with it. And the argument there is that the meaning of the Constitution is the original meaning. And so to interpret, in this case, the First Amendment correctly, we need to know the original meaning of the First Amendment. And I have a little bit of a quirky answer to your question, a complicated answer. It's not quirky because I'm quirky. It's because the historical record actually, I think, is a little bit different than we anticipate. My research leads me to believe is that there's no unambiguously clear meaning of what an establishment of religion is. And we can know some things about what the free exercise of religion is, but even when you read the drafting record, that is the drafting of the First Amendment, it's not crystal clear what this text meant. Now, I have a story of why the founders could adopt language that wasn't crystal clear in its meaning. We can talk about that if you want, but that's my conclusion, that we can know some things about the original meaning, but it's not nearly as clear as it might be useful for it to be. And therefore, if you want to be an originalist, if you want to follow the founders, you really have to recur to their philosophical thinking. You can't just look to the Constitution's drafting record, because it doesn't yield the results. The history is not as clear as we might otherwise want it to be.
Well, yeah, I think we would love to hear how you arrived at your conclusions. Please tell us your story.
Yeah, well, I mean, we forget. I suspect your listeners would not forget this, but most people forget this, that the people who wanted the Constitution at the time of the founding, they're called the Federalists. The people who were against ratification of the Constitution were the Anti-Federalists. The Federalists didn't think we needed a Bill of Rights, and they make their case in Federalist 84. The nature of the Constitution, they said your rights are going to be protected by constitutional structures, representation, separation of powers, not by a Bill of Rights. And so that's why we don't have a Bill of Rights originally. The Anti-Federalists said, well, we need a Bill of Rights for rights to be secure. And the deal was the Federalists, the pro-ratification party, says to the Anti-Federalists, okay, you vote for ratification, or at least don't oppose ratification, we'll adopt a Bill of Rights after the Constitution is adopted. And that effectively is what's happened, though the vote is very close. You know, in New York, the ratification vote was 30-27. Just simply amazing to think about. You know, 2 New Yorkers had voted differently. New York went to ratified, and even New York was the 10th state to ratify. You know, the Constitution is not going to work without New York. So the ratification vote was very close. So Federalists win. James Madison, who is a Federalist, says to his Federalist buddies, hey, you know, we promised a Bill of Rights, and we need to do this now. And the Federalists were like, no, forget it. We won. You know, we got the Constitution ratified. The Constitution doesn't need a Bill of Rights. And it was a real battle. And what Madison understood is the Anti-Federalists didn't really want a Bill of Rights. The Anti-Federalists wanted a second constitutional convention. And they wanted a second constitutional convention because they wanted to rewrite the Constitution. They wanted to scrap it. They wanted to do what the Federalists did, or what the drafters of the Constitution did to the Articles of Confederation. And what James Madison understood is, if we, the Federalists, that is, we who champion the Constitution, write amendments to the Constitution, will prevent a second constitutional convention, will defeat the Anti-Federalists, and the Constitution will be secure. And Madison was exactly right. So the people who did not want amendments wrote the Bill of Rights. And if you read the drafting record, what you see is they say things like, we have better things than drafting a Bill of Rights to do. And they say, well, we don't really care what they say. We just have to draft these amendments because we promised them. And what you get as a result is text without a clear meaning. We think of the drafting of the Bill of Rights, it must have been this great moment of constitutional design. It wasn't at all. It was, hey, we've got to get this stuff done because we promised it. Let's find some text that doesn't mess up the Constitution. Well, no one's in favor of a national establishment of religion. Let's just say that. There's no clarification of what an establishment of religion is. We're all for the free exercise of religion. Let's say that, without defining at all precisely what the free exercise of religion means. And they didn't think they needed to define these things. The problem is, 200 years later, when we need to interpret this text, what do these words mean? And that leads us a dilemma. We have these words in the Constitution that lack a clear meaning. To use more technical language, they're underdetermined, but we need to determine them. How do we do that? And my argument is, if we really want to follow the founders, well, we have to recur to their political philosophy, and that's the philosophy of natural rights.
And it's a little ironic, right? I mean, if I remember my Federalist 84 by Hamilton and my James Madison, James Wilson's opposition to having a Bill of Rights in the first place for the Federalists, that in part they were concerned that, you know, if you wrote these down, they'd be ambiguous and subject to contention and controversy, where for them there was no controversy because the government didn't have any power over those rights in the first place. And yet here we are today amidst a lot of controversy about the meaning of these things.
Yeah, no, they're exactly right. And they said things, just to be precise here, in Federalist 84, which you're right to cite, you know, you don't have to worry about the national government abridging the freedom of speech or freedom of the press. That's Hamilton's example, because there is no power in the national government to abridge the freedom of the press. Now, whether that was as true as Hamilton said, is debatable. I think is largely true, because the national government had far less powers than it exercises today. But nonetheless, we ended up with the Bill of Rights, and certainly today, the national government can in all sorts of ways abridge the freedom of the press, free exercise of religion. So it behooves us today to try to figure out what these constitutional words mean. And again, the larger argument of the book is, if you're going to follow the founders, you have to understand their political philosophy and adopt their principles. But we've forgotten what natural rights philosophy is, and so a lot of the book is just a sort of intellectual archaeology, trying to recover these older ideas. So at least we can consider them today, and judges can consider applying them.
Right, and that's a great segue into my next question, which is, how would you apply this natural rights understanding of religious liberty that we're discussing to modern Supreme Court cases, to jurisprudence today?
Yeah, well, let me give you a general answer, which is, it turns out the founders were much more Republican or Democratic than it's often thought. They're far less libertarian. And by that, I mean that they established government by the people, and that the natural rights understanding that I try to outline, and it's not my understanding of this, I'm trying to explain this is the founders' understanding, would mean there are very few things government can't do, but most things when it comes to church and state, the founders' position was you turn it over to local democratic majorities. So what can't government do? Well, government can't, as I said before, it can't make you worship. It can't, the government can't write prayers for you to say, can't punish you for not praying. But on all sorts of things, should government help fund religion? Should government exempt religious citizens from generally applicable laws? All these questions were to be handled by democratic majorities. And there's no wall of separation that religions can't participate in generally available programs. The founders' free exercise clause and establishment clause are much more democratic, meaning they don't restrict government nearly as much as liberal separationists would have us believe, or conservative exemptionists would have us believe.
Final question, going back to our original question that we posed, and to sum things up, is simply how did the founders understand religious liberty?
So they understood it as, we have a right to be free from government interference in a narrow domain of our natural liberty, especially pertaining to our religious worship. Other than that, when we join the social compact, when we become a member of the political community, we turn a lot of decision-making over to the community, which we participate in. They really believed in self-government. I'd actually say they believed in self-government more than we believe in self-government today. We like government by experts and government by judiciary. Maybe it's better, maybe it's not. To make that argument, we have to understand the founders' approach to constitutionalism. And so I take the position, and you were sort of alluding to this in the beginning, I take the position, not necessarily that the founders were right, but they offer an alternative that we ought to think through. And we can't think through their alternative if we don't understand them. They really do offer an alternative to modern constitutionalism, which in many cases is government by judiciary. Well, if we don't like government by judiciary, or we have reservations of government by judiciary, or we just want to understand the alternative, that alternative is the founders' constitutionalism. And my job as a scholar is simply to set forth that alternative, hopefully to make it clear, and then let the readers decide for themselves what they think is the best.
I think that's a great approach, and a very American and democratic approach, and hopefully we can engage more in that in our civil conversations. But Phillip Muñoz, author of Religious Liberty and the American Founding, I want to thank you very much for joining us today.
And if I can just add one thing, for any of those who made it to the end of this show, if you want a copy of the book, just write to me, send me an email. You can find me on the Notre Dame website. Be happy to send you a signed copy. I get a discount from the press, and happy to extend that discount to anyone who wants a copy of the book.
Great, thanks. And next time I see you, I'll bring my copy for you to sign.
Thanks so much. Really enjoyed it.
All right, thank you. And thank you all for joining us on this episode of Scholar Talks. Please check out our other videos in the series, Topics in Government and Civics. And please check out our series on the American founders that you can find on this channel.